According to my records, we made the original request with subpoenas for documents and witnesses on March 30th, 2022. April 1st, Mr. Hanneman, on behalf of the commission, issued the subpoenas, including for Major Jason Turner and for, I believe, retired Colonel Reeves.
That was prior to his retirement.
Right, and I believe they were served. In addition to 2 witnesses that have been subpoenaed not showing up, we requested documents from state police, including emails and text messages. While I get that they might have deleted text messages, I got a response yesterday saying we haven't had time to get the emails together and we don't have or need time to get the text messages. Okay. It's a different issue.
Yeah, let's hold that argument.
Yes, ma'am.
Because I'm just dealing with the 2 witnesses that are not here right now. So we have Kevin Reeves and Jason Turner, who are not present. The commission has the authority to hold the record open for their testimony at a later date if the commission so desires. And I believe Ms. Kraft has indicated that she would like a motion, to make a motion regarding that as well.
Before we get to that, is it the desire that we hold the hearing open for these witnesses?
It is my desire that they be held in contempt.
Well,
Under Rule
that was
13.
not the question.
I understand.
And I need an answer to the question. Do you desire that we hold the meeting open, and then you can make whatever motions you want? I just need an answer to that question.
Well, I've subpoenaed their testimony because I want their testimony. But holding the record open, if they're refusing to appear, doesn't help anything.
So is that a yes?
Well, I think it's a roundabout way, yes.
Me too.
However,
So we'll hold the matter open. Now, do you have a motion?
I do. I want them to be held in contempt under Rule 1317. They were properly served with subpoenas to be here. This commission is empowered to hold those individuals in contempt for not appearing pursuant to a lawful subpoena. We ask that they be found guilty of contempt by the commission in accordance with the rules and whatever punishment that is. Holding the record open is fine and dandy if they're going to show up, but they have expressed contempt for this commission and the lawful authority to issue subpoenas. Why they're not here, I have no idea. There was some sort of letter circulated by Mr. Unglesby on behalf of former Colonel Reeves saying he can't be here, he's not available. That's not enough. If my client doesn't show up, for example, under your rules, then you get to vote against him for not appearing to defend against the actions brought. But I ask that they be held in contempt, and I would move that they be held in contempt of this commission, holding the record open to make them have to come up here, pay attorney's fees, and whatever else the commission decides. Thank you, sir.
Does the commission want to take that motion under advisement at this point?
Yeah, and I would entertain a motion, take that
So moved.
motion under advisement.
Second.
Okay. We'll take it under advisement pursuant to the motion if the motion passes. And while the record is being held open, we can also obtain additional information on their non-appearance.
Do we need to vote on that?
Yes. Any discussion? All in favor?
Aye.
Okay.
Do we need a motion to hold the matter open, or my statement earlier is sufficient?
Why don't we make a motion?
We have a motion to hold the matter open for the continued testimony of these 2 witnesses upon their later appearance.
I would so move. Second.
Any discussion? All in favor?
Aye.
Any opposed? Okay, the ayes have it.
Ms. Holland, Mr. Sean, do you want to call your first witness?
I'm sorry, I have.
I'm sorry, you still
That's
have.
okay. I do have some more preliminary matters.
Yes.
As I'm quite confident you would suspect. We requested for subpoena on March 30th, 2022, certain documents from the Louisiana State Police. That subpoena was issued on April 1st. We received a response yesterday from Ms. Holland on April 12th. I would like to offer, file, and introduce into the record a copy of our original request, the subpoenas that were issued April 1, and Ms. Holland's request from yesterday, response yesterday.
No objection.
I don't know who needs the copies, but I guess we do.
Thank you.
Here is the problem. What we requested from state police for the purposes of my client defending himself against a 200-hour suspension were the following specific items which have not been produced. True and correct complete copies of any and all text messages and or emails between Superintendent Lamar Davis, Lieutenant Colonel Jay Oliphant, Lieutenant Draper Crane, Trooper Leander Journey, Trooper Troy Pichon, Captain Trioni Larvadane, Captain Salim El Amin, Major Jason Turner, Lieutenant Colonel Chavez Kamen, Lieutenant Colonel Kenny Van Buren, and/or Kevin Reeves regarding in any matter the following terms. I identified terms because the state police operates off of a central server. In order to search terms, if you provide them terms, they can simply search. Here were the terms: Carl Cavalier, Ronald Green, cover-up, excessive force, book, secondary employment, business, undercover name, pseudonym, pseudo-name, retaliation, assault, and/or battery. The response that I received from state police yesterday was that they don't have time or didn't have time or somehow couldn't get together the responsive documents for our subpoena. And specifically, what was responded to is in response to number 4, please find the enclosed responsive records : and this was their response. Overly burdensome, and we could not review all requested documents. Number 5, we requested true and correct complete copies of any and all text messages and/or emails between Superintendent Lamar Davis, Lieutenant Colonel Jay Oliphant, Lieutenant Draper Crane, Trooper Leander Journey, Trooper Troy Pichon, Captain Trioni Larvadane, Captain Salim El Amin, Major Jason Turner, Lieutenant Colonel Chavez Kamen, Lieutenant Colonel Kenny Van Buren, and/or Kevin Reeves, and Governor John Bell Edwards. Any or any of his representatives and/or aides regarding in any manner the following terms: Carl Cavalier, Ronald Green, cover-up, excessive force, book, secondary employment, business, undercover name, pseudonym, pseudo-name, retaliation, assault, and/or battery. The response from state police was as follows with respect to that subpoena. In response to number 5, please find the enclosed responsive documents : this was their response. Overly burdensome, and we could not review all requested documents. I get it, I'm not an impatient human being, but when I see press reports about the Louisiana State Police somehow wiping out phones, and they don't have emails, and they don't have text messages anymore, and they don't have video, and videos being held, I'm going to ask that state police be held in contempt under this Commission's Rule 13.17 for refusing to comply with a lawful subpoena that was issued for those documents. I specifically limited the terms because it is a very simple matter on their server. Enter the terms, it produces the emails. We also restricted the fields as it related to the individuals who were copied on or authors of those particular emails and/or text messages. Again, I would move that they be held in contempt. My client has a right to defend against a 200-hour suspension, and those rights are being denied. Thank you.
There was no motion to quash the subpoena request filed.
Is there a response?
Yes, we did receive Ms. Kraft's subpoena, and we did attempt to gather the information. The email search was sent to our IT personnel. A search was done on those terms. I contacted Mr. Conrad and told him that it was overly broad. We did not have the time to review the search to see if the terms that they were asking for yielded what Ms. Kraft would have looked for. As far as the text messages are concerned, our IT personnel had no way of even gathering that information. And I made that known to Ms. Kraft. We have no way of gathering it. They would probably have to do a search warrant to each of to the carrier in order to get that information, because we do not have the capability of doing it. And furthermore, I do not see where those search terms are necessarily.
Can I stop you just quickly? Do you agree that those communications were had, not necessarily in the response that you just read to us, but the communications relative that were had with your office?
Nope. I asked Mr. Conrad if he had a discussion with Ms. Holland regarding the production or late production of the records. He indicated no. In fact, the only discussion he indicated he had with Ms. Holland was about trying to settle this case. The discussion I had with Ms. Holland was approximately 10 minutes ago. Before we got up in the argument, she said, well, we just couldn't find him, it was a lot. That is not a motion to quash, it's not a timely objection to the subpoena, those are the discussions.
I have an email, I would have to find, telling Mr. Conrad that I was trying to gather everything. I gave him a date and a time, and then I contacted him to let him know that it was overly broad, we couldn't get it, and he said, give me what you have. And that's when my office went to his office with what we had. That's what happened. We gave him what we had.
What did you
Which
have?
was a lot. Yesterday afternoon, we brought them everything that, that we had, which was a lot.
But did any of it respond to those
Yes,
specific items?
Yes, we provided them with number one, which was everything in Car Cavalier's IA.
No, my question was, did anything that you produced, did you produce any emails or any?
Oh, no, I did not produce any emails, and I did not produce any text messages, and the reason I don't have any text messages, the search has been done, but we did not have time to go through.
You didn't have time to figure out whether one or two or three or whatever number that should have been produced?
It was a lot, and the search was done, and it was a lot. We did not have time to go through the emails. The text messages, we do not have. We were not even able to do a search on the text messages.
Would you like a continuance in this matter?
I'd like the documents,
I understand you want the documents.
and I'd like them held in contempt.
Do you want a continuance? We have your motion, I'm asking you whether you also want us to consider a continuance.
I think what I would prefer is holding the record open, and if we need to bring those back and bring the witnesses back, fine. But from our perspective, this was not a complicated request, and frankly, I'm a little shocked after the stuff at the legislature about wiping out phones, that they wouldn't have taken the time to try to get something to us in terms of emails. I don't want to continue this. My client is out 200 hours. Behind this, there's a termination because he spoke out. I can't, in good conscience, with a man with 4 kids, say, let's continue it until they decide they want to do their job. But I will suggest that holding the record open, and if I got to call these witnesses back up here and we got to deal with some evidence, I mean, that's how we're going to have to do it. But I don't think because they're state police, they get a pass on not complying with a lawful order.
No one takes the position that anybody gets a pass for complying with the law.
Yes, sir. Understood.
Just 1 second. Ms. Graff, you're certainly alleging misconduct on the part of the state police, is that correct?
Yes, sir.
Okay, well, I would make a motion that we move into executive session to discuss the allegations of misconduct. This did not come up until now, so obviously we didn't have notice of it, so it's not on the agenda. But I'll call for, I make that motion. Can I have a second?
Second.
Okay, we have a motion and a second. Please take a roll call vote.
Brian Crawford.
Yes.
Leonard Knapp.
Yes.
Robert Meir.
Yes.
Howard Perry.
Yes.
Jared Bricky.
Yes.
And Yulia Simi.
Yes. So we're going to go into executive